All right, as soon as we log on to YouTube, we'll get you sworn in and call the case. Uh-oh. All right, we will call case number JP 1-1 LT 2021-1733. It's Sean Manzur with an agent of Rachel Case versus John Witten. This property is located at 1613 35th Street, Wichita Falls, Texas, 76302. Is the plaintiff? All right, we will call case number JP 1-1 LT 2021-1733. It's Sean Manzur with an agent of Rachel Case versus John Witten. This property is located at 1613 35th Street, Wichita Falls, Texas, 76302. Is the plaintiff? All right, we will call. Oh man, can you hear that now? You can hear all that. LT 2021-1733. It's Sean Manzur with an agent. I don't know. I just closed it.
Oh.
Okay, is the plaintiff ready to proceed?
I am, and is John Witten on this as well?
No, ma'am. So there is no defendant. No, ma'am. So you may proceed. Rachel, let me get you sworn in real quick. I apologize. Do you swear to tell the whole truth and nothing but the truth, so help you God?
Yes, sir.
All right, go right ahead.
On January 12th, we certified mailed a 30-day notice to John Witten to vacate the premises. He is still currently in the property and has not vacated. Per his lease that I've also attached as one of the exhibits, he had until the end of February to vacate the premises and has not done so. So we are asking for the property.
Okay.
Hang on. We're asking for the property for holdover, for tenants holdover. And I think I've attached his lease explaining that as one of our exhibits as well.
Yes, ma'am. I appreciate all those exhibits. And you have a bond of possession, is that correct?
Yes, sir.
Okay. Oh, thank goodness. The generator just finally turned off. Perfect. Okay, so at this time, the court will rule in granting the plaintiff immediate possession of the property. We will, the monthly rent is $725, so that will be his, that is for unpaid rent. Okay, so his appeal bond, but you've got the bond for possession. He still has a right to appeal. He still has those 5 days. And if he does turn in, even if he does turn in the declaration, because you are wanting the holdover, the declaration doesn't cover that.
Correct. Which we have received that, but it was for.
You have or have not?
We have received the declaration, but since we were asking for holdover.
Yes.
Yeah.
Okay. Yes, I do see that. All right. Thank you. Okay. So we will get the judgment sent out to you today. Will you want that mailed or faxed or?
Can it be emailed?
It can be emailed. Yep. I've got Angela in here with me, so making sure I do everything right. So we'll get that emailed to you this morning after all of our hearings.
He was not present today. Do we have the 5-day waiting period still, or can we come file that with you today?
No, you can come file that bond, that writ of possession today. You sure can.
And does our office with the COVID rules need to come in person? Or do we need to call up there and speak with Miss Angela?
No, you can come in person.
Okay, sounds good.
All right, thank you, Bill.
All right, thank you. Have a great day.
Have a good day.
Bye.
Bye. All right, so we will now do, let's get the lady in the courtroom. Let's do, we've got a new defendant. All right, so we've got Kara. Let's see if we're going to do that again. All right, we're going to try. We're having some other. Oh, that says, okay, well, we've got it right there. That's saying stop live stream, but I guess we're good. Okay. All right, both of your, Mr. Callaway has chimed in as well, but we're going to do him second. Tara was here first, so we're going to do that one first, okay?
Okay.
Oh, hold on. All right. Kara, can you hear me okay?
Yes, sir.
Okay. All right. Oh, Tara, we have a Tara and a Kara. Tara, I'm going to refer to you as Miss Gann.
Okay.
That sounds
Okay.
good.
And then Tara, how do you pronounce your last name?
Sites.
Sites. Okay. So we will be Miss Gann and Miss Sites, just so that I'm not confused. It'll make that easier on me. So,
Okay.
all right. Okay, we're going to call in case number JP 1-1 LT 2021-1736. This is an eviction hearing, and it is Rebecca Cunningham versus Tara Sites, Kenneth Lewis, and Colt Anson. This property is located at 4101 Mustang Road, Wichita Falls, Texas, 76306. If both of y'all could please raise your right hand, I'm going to get both of y'all sworn in. You swear to tell the whole truth and nothing but the truth, so help you God.
Yes.
Okay. All right. Ms. Gann, you're an agent of service for Ms. Cunningham. Being the plaintiff, you can proceed first. Go right ahead.
I received a notice from the property manager, Melissa McCrae, that the landlord would like to do a non-renewal of lease.
Okay.
I guess the client is on a month-to-month basis, and she would like to non-renew her lease.
Let me get to, now you have provided the court with some exhibits.
Yes.
Okay, we're going to make some copies and present that. I don't know if this is a little too close or not. But we're going to make some copies real quick and provide these to the defendant. Ms. Gann, can you hear that high pitch?
Can, yes.
Okay. And Ms. Sites, can you hear it as well?
Yes. Some of it broke up.
Okay. Did you hear everything that I was saying?
I heard about you making copies,
Yes, ma'am.
but that was all I heard.
Okay. So the landlord has provided some documents to the court And we're just gonna make a copy of those documents so that you're aware of what they're.
Okay.
Hey, sorry about that. See if we can. All right, we'll try that. It's crazy.
So it looks like the more I talk, the higher it goes. So I'll try to keep my sentences brief and short. All right. Very good. Okay, Miss Gann, when did the lease expire? I'm trying to find that.
On the lease, it expired last year on March 31st. And
Okay.
she's been on a month-to-month ever since.
So March 31st of 2020.
Yes.
Okay. And then y'all notified her that y'all were going to stop the month-to-month on the 28th?
Yeah, she was received
sorry.
an eviction notice to quit on March the 1st.
March the 1st.
Let's see, and then she received,
Well, I'm showing the above reference lease ends on 2/28, which was the end of February. So March the 1st would be in her. Okay. Okay, let's see. And how was she notified, or how was the defendant notified?
by certified mail.
Certified mail, and I think you provided that.
On March
Yes.
3rd.
So she was notified on March the 1st that her month-to-month would end. Is that right?
Yes, sir.
Okay. Okay, Ms. Seitz, do you have anything that you would, oh, did you have anything else, Ms. Gann?
No, not at this moment, no.
Okay. Ms. Seitz, do you have anything that you would like the court to know?
Well, it says here that it was delivered on March 3rd, not March 1st. Whenever I received the item.
The notice to vacate?
Yes, the exhibit 3. It shows that I was delivered March 3rd at 12:41 p.m. Not the 1st. And I also, I had given the landlord, I had talked to her and Rebecca, and she had told me that she was going to renew the lease with me. And then all of a sudden, March 3rd, I get this saying that she was not. After I had sent her a $3,400 cashier's check that I deposited it into her personal account. And I mean, I don't have anywhere to go right now. And she told me I could start catching up on my rent and everything. And this was all between me and Rebecca. This other lady, and this was, I believe, I have text messages, but I believe it was like February, I don't know, the middle of February, I'm going to believe, whenever I talked to the landlady herself.
You're talking about Miss Cunningham? Rebecca?
Yes.
Okay. Okay, hold on 1 second. Ms. Gann, did Miss Cunningham, to your knowledge, give any other notice to vacate other than the March 1st or March 3rd notice?
I do not believe so.
Okay.
Let's see. It looks like there was, nope, that was the same one. No, that was the same. Yeah, just the one.
Okay. And Ms. Sides, did you receive that notice in the mail?
Yes, on March 3rd.
Okay. Okay. All right. Okay, well, just a little education, that this is what the statute says in regards to a month-to-month lease agreement. So if the lease is over and she continued to do a month-to-month until the landlord doesn't want to continue that, the landlord has to give a 30-day notice that she's going to terminate her month-to-month. And then when that 30-day notice is up, then the tenant has not moved out of the home, then she has to give a 3-day notice to vacate. Hold on.
It looks like she did receive a notice. I'm sorry.
No, you're fine.
On
Yeah.
February 28th. of a notice of landlord's intent to non-renew.
Correct. So if that was on February the 28th of 2021, then that's her 30-day notice that she's not going to renew or accept the month-to-month anymore. So that would carry until March the 28th. So
Okay.
on March the 29th is when she can get her 3-day notice to vacate. And then if she hasn't vacated, then that's when she would come down and file the eviction. But because she was on a month-to-month lease, you have to give a full month notice, 30-day notice that, hey, we're going to terminate this month-to-month lease. Because it says right here, and this is what I wanted to look up to make sure. I said a tenancy at will with fixed rental payments, such as month-to-month agreements. It's a 3-day written notice unless the lease specifies otherwise. But you must first give a termination notice of at least one rental period. So whatever that rental period is, that 30 days, she has to give a notice that we're going to terminate the month-to-month. And then if she doesn't move out in those 30 days, then you have to give a 3-day notice to vacate. So at this time, unless there's something else, and I'm going through this again, Miss Gann, just so that I'm not missing anything.
Of course.
I'm not showing that 30-day notice that she's going to terminate the month-to-month was given. I'm showing a 3-day notice was given, even if it was given on the 1st or the 3rd. That was plenty enough time because it was filed on the 8th. So even if she delivered it on March the 3rd, that's still 5 days. So she falls plenty of time there. But I'm not showing that a 30-day notice to terminate her month-to-month agreement was filed. But if you see that,
Is
please.
the notice of the landlord's intent to non-renew on February 28th or looks like it was signed by the property manager on February the 9th. And that letting her know that it ends on the 28th.
Right, and this notice is great. She has to give a full rental period to lapse. So she gave it. So she signed it on the 9th, February the 9th, which means on March the 9th, if she didn't vacate, she had to give her 3-day notice to vacate. So then on March the 9th, that would be 10th, 11th, and 12th. Then on March the 12th or 13th, she could come down and file the paperwork for the eviction process. It just looks like she didn't give her enough time because she has to give the full rental time period.
Okay, yeah, I filed on the 8th.
On the 8th, yes, ma'am. So she didn't have that full 30 days and then the full 3-day notice to vacate.
So I just missed it by a day and 3 days.
Well, about
4 days.
About 4 days, yes, ma'am. And she would have to be given the 3-day notice after the 30-day time period.
Okay.
Got that full 30 days to move out. On that 31st day, if she's not out of that property, you can give her that notice to vacate, and that's day 1, then day 2, and then day 3, and then on the next day you can file the eviction if she hasn't vacated. Yes, ma'am.
Okay.
Yeah, I'm sorry, and that's why I was trying to go through this just kind of with a fine-tooth comb just to make sure the court wasn't overlooking anything. But it looks like she gave her the notice. I mean, it looks like it's all here. We're just not in the right time period on our days.
Okay.
Okay.
So do we have to start this process all over again?
Yes, ma'am. Yes, ma'am.
Awesome.
Now, let me follow up with that because you did give her the 30-day notice, and Ms. Sides, I will follow up on this and let both parties know because it looks like they did give you the 30-day notice to vacate already. So they may only have to just give you a 3-day notice to vacate. which could be delivered today, and then you can come and file the eviction. But I will check into that to make sure, because I don't want to give either side the wrong information. But I will get back with both of y'all today on that, okay?
Yes, sir.
Okay, and Ms. Seitz, before you leave today, I'll have one of my clerks get a good contact number for you, okay, ma'am?
Yes, sir.
Okay, all right. Did you have any other questions, Ms. Seitz?
Well, I mean, with all this going on, it says in here that I can sign this thing.
The declaration?
Yes,
Yes, ma'am.
because right now I don't have a place and I'm a single mom of 3.
Yes, ma'am. Yes, ma'am. You can sign that declaration. However, that declaration only covers the tenant, if they are filing for non-payment of rent. So
They are filing for that as well.
no, ma'am, they're just asking for a holdover. They do not want to renew the lease. So they're not asking for any non-payment of rent.
Well, it says plaintiff also sues for unpaid rent and court costs on the very first page.
No, I just filed just for holdover.
Okay,
ma'am.
well, I have my copy with me.
Okay.
And it says for the property, and underneath it, the first line says for unpaid rent and court costs.
Okay. I'll come in there and take a look at it. Hold on one second. Okay.
Yes, sir.
Is that just the summons?
Yes.
Yes. Yep, and it's left blank. So there's no amount that's typed in there. It would say like $700 and court cost of $171. It would be filled out, but it's just left blank, so they're not asking for anything.
Okay.
Okay?
All right.
Uh-huh.
Ms. Gann, what she was referring to was the court summons, and it has a line there that says,
Yes.
and I told her that it's not typed in, so it doesn't reflect anything that y'all are asking for. Okay, so at this time, I will dismiss this case. But I will get back in touch with both of y'all later this afternoon in regards to what I found out about the notice and stuff like that, okay?
Okay,
Yes,
wonderful.
sir.
Thank you.
All right, thank you. And this concludes this hearing.
Where do you do that at?
Okay, looks like Mr. Callaway is here on this one. Good morning, Mr. Callaway. How are you today, sir? Looks like you may be muted. Is there any way that you could unmute your? There you go. Can you hear me okay, sir? All right. Ms. Gann, is this going to be the same situation? Okay. Okay. So I'm just gonna, okay. Well, you don't mind if we then expedite this and I'll just inform Mr. Callaway. Is there anything, okay. Let me call the case to order here. Mr. Callaway, can you hear me okay? Okay, you may want to, I can't hear you. No, sir. It looks like you're unmuted, but I just don't have any audio. Did you send me those email? Yeah. Did you print those already?
Yeah,
You did?
is it all the stuff that?
Can you hear me now?
Yes, sir. We sure can.
Yeah. It's pretty old, I don't know.
No, on the Proctor case.
Oh, no. Yeah.
Okay, we're going to call case number LT 2021-1735 in regards to Clint Winnington, and an acting agent of Kara Gann versus Lawrence Callaway. This property is located at 2152 Avenue F, apartment 1. Is the plaintiff ready to proceed? Ms. Gann?
Yes.
Okay,
Sorry.
and that's okay. And Mr. Callaway, are you ready to proceed?
Yes.
Okay, I want to get everybody sworn in real quick. You'll raise your right hand. You swear to tell the whole truth and nothing but the truth, so help you God.
Yes.
Yes.
All right. Okay, Ms. Gann, if you just want to give us a brief rundown real quick, and then we'll tackle that other issue.
Yes. Melissa McCray is the property manager on the property. She asked
Okay.
me to do a holdover for non-renewal of lease.
Okay. All right. Mr. Callaway, it looks like the land or the plaintiff has submitted some documents to the court. They emailed these into us earlier this last or later middle part of last week. Those documents show your lease agreement, and they also show some dates that you were notified, whether they were by first-class mail or hand-delivered, some documents in regards to them wanting to evict you, and that they did not want to continue your month-to-month lease. Is that correct?
I got a letter from them, but may I say something?
Yes,
Yeah.
sir. You sure may.
I've been in this situation once before, and I talked to the owner, and he said, and she said that if I paid it by the time the paperwork got submitted to the courts, then don't worry about it. Just get it caught up. So I got it caught up that time, and this time is I thought when the paper came in, I thought I was going to say the same thing. I thought they were going to do the same thing. So I never opened that. I did because I was working on the money as I told him. I said, listen, I'm gonna get this money to you. And I didn't open it up. And she said, I need to, well, basically I need to open it up and read it, but I just thought it said the same thing it said last time. And I didn't open it up, which is my fault. And then I found out about the lease situation, and they didn't want to renew it, which I didn't understand why. I understand why, but I thought that could have been, because I talked to him a couple of times and he never said anything about it. So
Okay.
I don't know. And
Okay. If there is any form of agreement outside the court, which means away from me, and that's between you and the landlord, that's between you and the landlord.
yes, sir.
So whether or not y'all make a verbal agreement and one side doesn't follow through or the other side doesn't follow through, that's strictly between landlord tenant. The court has no jurisdiction between any sort of verbal agreement between both parties. Okay.
Okay.
However, what we did notice in this case is that proper notice was not given to you.
Okay.
In your arrangement that you have where you were going month to month, okay, a month-to-month lease, they notified you that they wanted to terminate your month-to-month lease, and they gave you so many days to move out, but they failed to follow up with another notice that they're supposed to do. So when they gave you the notice to terminate your lease, they're supposed to give you 30 days, which is a rental period. At the end of those 30 days, if you haven't moved out, they're supposed to give you a 3-day notice to vacate. So one notice is telling you, hey, we're going to stop this month to month. And then the next notice is your notice to vacate. So they didn't do that. So at this time, I am dismissing this case because proper notice wasn't given.
Okay.
However, because they have given you that 30-day lease, and what I need to find out is, and I will find out today and get back with both you and the plaintiff, is if they have to give you another 30-day lease, another 30-day notice, and then their 3-day notice, or since they've already given you that 30-day notice and that 30 days has passed, they gave it to you back in February, can they just give you the 3-day notice? So that's what I have to find out today. I don't want to give y'all the wrong information. What my gut tells me is that they only have to give you a 3-day notice because that full 30 days has passed. What happened is they gave you the 30-day notice. That 30-day notice didn't all the way pass, and then they came and filed the paperwork. It's not that they did that on purpose to try to get one over you. It's just a small little one-line rule in the law that says, oh yeah, don't forget you have to do this too. So they did everything correctly. They just kind of fell short on their time frame. Okay. And that's, that's what we saw. We caught that. It's just a small technicality. But I think, you can reach out to the landlord. I can't give you any legal advice. The landlord can dismiss or not file if the landlord wants to. But once again, that's strictly what the landlord wants to do if they want to do that. But Mr. Calloway, what is a good number that I can reach you at, or one of my staff?
940-923-4017.
Okay. Once again, 940-923-4017.
Yes, sir.
Okay, so one of my clerks or one of my staff will reach out to you today and let you know what we found out. But at this point, this case is dismissed because the proper notice wasn't given. Okay, sir?
Okay, what question? If because I'm a disabled veteran and I went through a program which they are still looking over applications, but if the 30 days was, if they did the 30 days and then they give me a 3-day notice, my question is, I can't believe this is happening, but my best chance is to talk to the owner and see what we can work out. And
I can't give you legal advice. I sure can. If you want to reach out to the landlord, you're more than welcome to. That once again, that will be between you and him. Yes, sir.
Okay, so the 3-day, if all they gotta do is the 3 days, I mean, it's hard to find a place.
Right. Technically, what would happen if they're able to give you a 3-day notice, they could come out today. So today's Monday. So Tuesday, Wednesday, Thursday. If you were not out of the house by Thursday, they come down here and file the paperwork for the eviction. And then we will schedule an eviction anywhere from 10 to 20 days out. Normally we shoot for about 14 or 15 days out. And then you would have your eviction hearing just like this again. Now, maybe in 14 or 15 days, it may be in person. We may be able to have it here at the courthouse, or we would have it over Zoom. Yes, sir.
Okay, then. Okay.
Okay.
All right. That's it.
All right. Thank you, sir. You have a good day. Okay.
You too.
Ms. Gann, did you have anything?
No, that's it.
Okay. All right. I'll reach out to y'all just as soon as I can.
Okay, then.
All right. Thank you.
Thank you.
Yes, sir.
Thank you.
Thank you, ma'am. Oh, shoot.
With 10 days left, it's crunch time, so sharing a couple of my favorite packing hacks. Grab your glasses with your socks and you don't waste paper and you accomplish 2 things at once.
Do a little bit. Thank you, though. People are here. One of our people.
Oh, for 10 o'clock?
Mhm.
All right. Well, it's almost 10.
Yeah.
Oh,
Let's see here.
here's this
Admit.
stuff still sincere.
Admit.
Judge, can you hear me okay?
I can. Can everybody hear me okay? I think our generator with the county has, I think we're on good terms with the generator. So, all right, give me 1 second here. All right, we will call case number LT 2021-1739. This is an eviction case. Texas Mitchell's LLC versus Steve Proctor and all other occupants. This address is located at 906 Van Buren, Wichita Falls, Texas 76301. Is the plaintiff ready to proceed in this case?
We are, Judge.
Is the defendant ready to proceed?
Yes, Your Honor.
Okay, thank you. Okay, if I could get everybody sworn in real quick. You swear to tell the whole truth and nothing but the truth, so help you God.
Oh, Mike, you're going to need to unmute yourself.
Oh, yes.
Yes, sir. Sorry, I do.
That's okay. Thank you,
I'm
sir.
used to teaching school where you have to mute everybody up. Sorry.
I understand. All righty. The plaintiff may proceed.
Thank you, Judge. Judge, we'll just begin by giving you a brief overview here. This is the exact same case that this court has heard before. We just had to refile or dismiss and refile it to clean it up a little bit. And we asked the court to take judicial notice of cause number JP1-1-LT2020-1641. We provide a copy to the court and to opposing counsel, the judgment of eviction. It's the same defendant, the same issues that this court has heard before. We just needed to refile and clean it up. And so, I mean, essentially, I'm going to have Mr. Mitchell testify the exact same thing that this court's already heard and ruled in his favor. Mr. Mitchell, we'll go ahead and call Mr. Mitchell at this time, Judge.
Yes, sir.
Okay, you may proceed. He's been sworn in, so you may proceed.
Thanks. Mr. Mitchell, why don't you begin by introducing yourself to the court and state your full name for the record?
My name is Michael Mitchell. I am
Okay.
part owner and I guess, president of Texas Mitchell's LLC.
Okay. And do you have a tenant at, well, first of all, do you through your company own 906 Van Buren, Wichita Falls, Texas?
We do, yes, sir.
And do you have a tenant there?
I do.
Okay. And is that tenant Steve Proctor?
Yes, it is.
And have you had some issues with Mr. Proctor?
Yeah, starting in November.
Okay, what?
Sorry, go ahead.
Let's just start with that. No, go ahead. Just kind of tell the judge real briefly, what are some of the issues that you've had with Mr. Proctor?
Your Honor,
Yeah.
at this point, I need to object to anything going prior to the eviction filed this year in February.
Why?
Yeah, I'm sorry, y'all were, you had objected when Mr. Stilson was still speaking. Could you repeat that objection? I'm sorry.
Yes, Your Honor. The pleading upon which they are proceeding only relates to an eviction filed March the 9th of this year. So to the extent that Mr. Mitchell's testimony goes to prior matters, we object as non-relevant because they dismissed their participation in the appeal.
We're allowed to dismiss and refile a case without prejudice, Judge, and that's what happened. We can absolutely bring an appeal, an eviction on something prior that happened to a previous eviction if we're the one. They've never received an adverse ruling. In fact, the court ruled in our favor. That eviction doesn't, or that we're asked that the court allow us to proceed.
Yeah.
However, Your Honor, the prior eviction included unpaid rent. This eviction does not. And to that extent, we object.
Not sure what that objection is. Judge, may we proceed?
Hold on one second. Let me look at one thing real quick. I'll overrule the objection.
Thank you. Mr. Mitchell, do you want to unmute yourself and proceed?
Sure. So first issue was a discussion with Mr. Proctor concerning a water heater. He had replaced a water heater. Before I purchased the building, he had said there was an issue with the water heater and he was going to replace it. He said that he had done so. And then in November timeframe.
Excuse me, I'm hardly able to hear Mr. Mitchell. If we can increase the volume or something.
I think that would be a
speak louder if you'd like. Can you hear me better, Ms. Crampton?
I'm not Miss Crampton. I'm Miss Norman. Miss Crampton is not the lawyer in this case.
Well, it says Holly Crampton on the bottom.
Sorry.
I understand that. That's because I was using her Zoom.
Okay. Well, my apologies, Miss Norman. Yes. Can you hear me better now?
If you'll speak up, I can hear you.
Okay. So previous to purchasing the building, I was told by Mr. Proctor that there was an issue with the water heater and he would be replacing it. I was told that he had done so when I purchased the building. He told me in November that he had had another issue with the water heater and had replaced it with the new one and gave me a receipt. I told him that we had had this discussion before, that no unauthorized repairs would be reimbursed, and that all repairs needed to go through me so that I could use licensed and bonded contractors. And at that point, we just went ahead and moved forward. Since that time, he's also told me that he was having a little tough time with paying rent and asked if other tenants could move in. And I told him they would have to go through the process to be approved just like anybody else. But then nobody else could move in until they've been through that process. And it appears that several people have moved in with him into the property.
And that's against your lease, correct?
That is correct.
Okay. So both the unauthorized repairs and having new people move in are against the terms and conditions of the residential lease that y'all signed. Is that correct?
Yes, sir.
Judge, at this time, we'd offer plaintiffs one, the residential lease that's been emailed both to the court and opposing counsel.
Your Honor, to the extent it was not provided timely, I object. Otherwise, the lease is the lease.
Sorry, I think I was muted. I apologize. So the objection was in regards to the time that the lease was entered. Is that what you're asking for, Ms. Norman? Can you hear me okay, Ms.?
No, I didn't hear you.
Okay, I said your objection was for the time that the document was admitted to the court.
Yes, Your Honor.
Okay, all right. That objection is overruled. We'll allow it. That it will be entered in as exhibit number 1.
Thank you, Judge. And Mr. Mitchell, did you provide a notice to vacate to the tenant in this case?
Yes, sir, I did. I sent it both by certified and regular mail.
And was that notice to vacate dated February 2nd?
Yes, sir.
Told him you had 3 days to vacate?
That is correct.
Okay. Did you, has he vacated?
He is not. As a matter of fact, it looks like more people have moved in.
Okay. And Judge, at this time, we'll offer a copy of the notice to vacate. That will, go ahead and mark that as landlord or petitioners 2, which has been provided both to the court and to opposing counsel.
Okay.
Is that the letter that was provided this morning, Your Honor?
Yes.
No objection.
Thank you. So Mr. Mitchell, just to be clear, Mr. Proctor has violated the terms and conditions of the lease that you two signed. Is that correct?
That is correct. Yes, sir.
Okay. You've sent him a notice to vacate, both by regular and by certified mail.
That is correct.
And despite that, he remains, as he has for several months now, in the property. Is that correct?
That is correct.
And you're asking that this court sustain your petition and enter a judgment evicting Mr. Proctor. Is that correct?
That is correct. Yes, sir.
Okay. Pass the witness, Judge.
No questions.
Judge, at this time, the petitioner rests.
Defendant, you may proceed if you have anything.
I don't believe so, Your Honor. Just a question as to the amount of the bond.
Okay. Give me 1 second on that. Hold on.
And just to be clear, Judge, we're also, of course, asking for court costs, post-judgment interest. And we believe a reasonable bond in this case, given that this is clearly going to be litigated, we would ask for A bond in the amount of 1,100.
They typically, we just do 1 month's rent. I know last time,
Last time was 550, Judge.
550. So that's what we'll do as well again on the bond amount.
Yes, Judge.
I'm sorry, sir.
I said, yes, Your Honor.
Oh,
I
okay.
apologize.
No, that's okay. At this time, the court will rule in favor of the plaintiff, granting possession of the property, and that bond or appeal amount will be $550. And we'll
Thank you, Your Honor.
You're welcome. We'll also grant court cost as well.
And thank you, Judge. And I believe there's a box as well for interest on the
yes.
judgment.
Yes, sir. Yes,
5%. So
yes, sir.
No, that's fine.
Yep, that is correct. All righty, that will conclude this hearing. Thank you.
Thank you, Your Honor.
Will the court be sending a signed order to us?
Yes, ma'am. Would you prefer us to email that, fax it, or mail it?
Email it, Your Honor,
Okay.
to the address on the answer that was filed.
Yes, ma'am. We will do that today. We sure will.
Thank you.
All right. Thank you.
Thank you, Judge.
Have a great day.
You bet. Y'all have a good day too. Thank y'all for your patience.
Mhm.
All right. We are. Good morning. I think it shows you may be muted.
Okay, Shamika.
Okay,
Oh, there you go. How are you today?
I'm good. How are you?
I'm doing good. Who are you with today?
I am Carrie Simpson. I'm with Hardy Real Estate and Construction. And we are filing an eviction against Jessica Hawley.
Oh, okay.
Let's see who she is.
All right. We have somebody here. They showed up to the courthouse. So we have a docking station in the courtroom for defendants that don't have the access. We have to provide access. So we're checking to see who she's with.
She's with James Prince.
Oh, she's with James.
Yeah.
Okay, so she's with Raymond White.
Yes.
And he hasn't checked in.
No, just she.
Okay. Okay. All righty. Let me get to that case. Sorry for the delay. We had attorneys on both sides for an eviction case.
Okay.
Oh, man. Yeah.
I've never heard of that.
It took a little longer than anticipated, so I appreciate your patience.
Okay.
Let me see. I'm not showing that we have. Oh, that's James. That may be Prince right there. James.
Mm-hmm.
Okay. All right. So our plaintiff is here on the other case, and nobody else is out there in the hallway. Okay. All right.
That's the response I've gotten as well.
Okay. All right. Okay. So we'll go ahead and call this case to order. We have case number JP 1-1 LT 2021-1746. This is Hallmark Properties versus Jessica Holly.
Yes.
This is an eviction case, and this property is located at 4318 Faith Road, Apartment 2, Wichita Falls, Texas 76308. Is the plaintiff ready to proceed?
Yes.
Okay. Is the defendant ready to proceed? Without there being an answer, I'm not showing anybody in our waiting room, and there's nobody in the hallway or the courtroom, so the defendant has not shown. I'm going to go ahead and get you sworn in. Do you swear to tell the truth and nothing but the truth, so help you God?
I do.
Okay, and it's Miss Simpson?
Yes.
Okay, Miss Simpson, you may proceed.
Okay. We acquired the property on January 29th, and I gave notice to the tenants, all tenants, of the new ownership and management, and got no response from the tenant. Left an application for her to fill out so I could have more information on them, and I still got no response. So I went, after February's rent was late, I went to the property, knocked on the door. A gentleman friend of hers answered, and I spoke with him about not getting a response, and then I needed to speak with her about the rent. And I got nothing. She never came to the door. She never called me. So I proceeded to try again and was only able to speak with him. I think several days went on, and she finally texted me. I got her to text me. I've got another number for her. And she indicated she was moving out by the end of the month.
Okay.
That was the end of February. I said, well, she says, I can't pay you and move out also. And I said, okay, understood.
Mm-hmm.
So I said, but I have to serve you an eviction notice in order to stay in compliance. So whether or not you pay or leave, I still have to serve you notice. So I went by that day, dropped off a notice on the 11th of February, taped it to the exterior of the door. And then I got received a rude phone call from her gentleman friend, letting me know I had no right to do that. So she's not responded to me. She's not had a conversation with me since then. She won't answer the door. She won't answer a phone call or text. No cooperation whatsoever. I even text her later on in the month and told her that, they opened up assistance for landlords. I could help her with some assistance, and she did not respond. So here we are. It's
Okay.
now March. She never responded for March's rent, and I still can't get her to respond.
Okay. So since are you asking for unpaid rent as part of the eviction? And the reason I ask that is there is, you've heard of the declaration.
Right.
Okay.
But
So the declaration covers any tenants that are evicted for non-payment of rent. So if they have until the writ of possession is served or issued. So basically what that means that even if we rule in favor for you today, they can come in tomorrow, they can come in Tuesday, Wednesday, Thursday, Friday. And if they file the eviction, then we have to stop and abate the case. And that's
if they filed the eviction?
I'm sorry, if they filed the declaration, I apologize.
Oh, okay.
Yeah,
Okay.
if they file the declaration, so they can still file that even after judgment has been rendered in an eviction case. So you may just want to be made aware of that they still have that option and opportunity. And what that means is, say that if the constables, say you have to come in and file the writ of possession, which is at 2:05 because they're refusing to leave.
Right.
Constable will go give them a 24-hour notice to vacate. Then the constable will meet you at the property to keep the peace while you're able to go in and remove everything of value and place it by the curb.
Right.
So if the constables show up for that writ of possession and y'all are in the process of ready to go in and start removing things, and they say, no, 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 I have this declaration, the constable will stop immediately and bring that paper to the court, and then it abates the case or puts the case on hold until the CDC declaration timeframe is over per the federal government.
But if she signs that declaration, does she not have to do everything in her rights to come up with rent and pay or for assistance? I mean, we're not getting communication at all.
Sure.
That there should be some limitations to that.
Right. As far as what the federal government has told the courts, that if a defendant turns in that document, it's a sworn statement. So if they sign it, it's a sworn statement, and we have to take it on that face value, that everything that they signed off on is true and correct. The plaintiff, the landlord, has a right to contest that declaration. So once we have that declaration from a defendant, the plaintiff has a right to contest it. You would submit that in writing. Hey, I would like to contest that declaration. Then we would schedule a hearing. And I would hear the evidence, or not really the evidence, since it's a sworn statement, the burden of proof would be on the plaintiff, you, to prove beyond a reasonable doubt that this declaration is incorrect or false. And the fine line is not what you may think or what you may know, but what can you prove? And some of those bullet points that they sign off on, it's open to a lot of interpretation. Let me just put it that way. But you still have that right to contest that. You sure do. And they also have the new diversion program through the state of Texas, that if a plaintiff and a defendant want to work together to try to tap into some money through the state of Texas, there's also that program as well. But once again,
she would have to communicate with me in order to do that.
you are correct. Yes, ma'am. So
Okay,
I just wanted to advise you, and on your petition, you're also stating unpaid rent and other grounds. But because you are asking for unpaid rent at any time, they can come and still file that declaration. I just want.
Okay, so I understand. What other options? And I'm not going to see a penny of that rent. So suing for that is just ridiculous anyways. What other options are there to evict? I mean,
you can either evict for unpaid rent or other grounds, which is what you've listed.
Your other grounds, I still have to prove.
Well, right. And through the course of what you've stated, you have attempted to communicate with them, and they're not communicating with you in regards to the lease information. You've given them the notice of new ownership, but they haven't come in to fill out their paperwork for, whatever you need to have for them being the new owner. Correct?
Correct. I just don't see me getting that judgment either. They have a lease with the previous owner, and therefore that stands.
But
she has a written lease with the previous owner, and I have to honor that lease.
That is correct. But I mean, as of right now, yes, you are entitled to your judgment, because it's a default judgment because they're not here. So what you're asking for, you are going to get today. I just wanted you to be aware of, with you asking for unpaid rent, they can still file that declaration. Yes, ma'am.
Right. I guess that's the only route I can go, because I cannot prove that he's staying there. He doesn't stay there the whole time.
Okay.
He's there often, but I can't prove that he doesn't leave. And that's the only other default thing I could think of.
Yes, ma'am. And what we've been told is that, you know, if on our abated cases that have already been abated because declarations have been filed, the deadline as of right now today is March the 31st. So that abatement period ends at the end of this month. So starting next month, we'll be hearing cases that have been abated since the summer of last year. So hopefully, and they won't extend it. Now they still may, the federal government may come in and extend that again, but as of right now, they haven't extended it. It will end on March the 31st. Okay.
Okay.
All right. So at this time, the court will rule in regards to the plaintiff granting possession of the property located at 4318. Now today being the 22nd, is that right? Already? Holy cow. They have 5 days to appeal the decision of the court. That 5th day is the 27th, which falls on a Saturday. So they have until Monday, the 29th to file their appeal. And then on the 30th, you could come in and get that writ of possession if they have failed to vacate.
Okay.
Okay. All right. Any other questions for the court, Ms. Simpson?
Just one question.
Yes,
If
ma'am.
they won't answer the door when I go on the 29th,
Well, you don't have to communicate with them anymore. So on the third, if they're still there on the 29th and you come up on midnight on the 29th, if they're still there, you can come up here to our office, file for that writ of possession, which is 205. Now, of course, you want to make sure that they're there or not there before you come up and spend 205 because they may move out.
right?
And so your question is, what happens if they don't answer?
Yeah.
Yeah.
I do have the legal right to go in, but I mean, I take my life a little bit more seriously than that. People can be
Totally
jerks.
I totally understand. Yeah.
Okay.
Yeah. I wish I had an answer for that, but yeah, that would be legal advice and I can't do that. So
I'll take somebody big with me.
there you go. Yes, ma'am.
Okay.
Yes, ma'am. Did you have any other questions?
I don't think so. I think that's
All
it.
righty. All right. Well, that will conclude this hearing. Good luck in your case.
Thank you. Have a good day.
You too. Bye-bye.
Bye.
Yes. Yep.
And then that goes in the courtroom. I don't know if I need to go in there and do anything.
And what's her name?
Shamika.
She lives there.
I guess so, yeah.
Oh, and all others. Okay, she did right there.
What kind of appeal bond are you gonna put on this?
Whatever the one was, I think it's 900.
Yeah.
So he is asking for unpaid rent.
Yeah.
Oh, wait, no, he crossed that out, didn't he? Good morning, Mr. Prince. Can you hear me? It looks like you're muted. So if there's any way that you could unmute yourself, that way we could hear you. Yeah, we may have to call him. First to give a notice to vacate. Let me see.
He said his kids are gonna help him.
Chat. Somebody chat with me. No, oh, he have no mic. Okay, so what we're gonna do is we're just gonna call you guys, and I will use the speakerphone in my office. There is a defendant here. They are in our courtroom. So we will get you on speakerphone first, and then we'll get them, okay? So just give us 1 minute, okay? Thank you. Could you type in your cell phone number, please, on a number that we can call you at? Oh, there it is. Is it 855? It is. Yeah. Okay. All right. Great. Thank you. We will call that in just a minute. Thank you. Good morning. How are you, ma'am?
Hello.
Good. All right. If you'll give us just 1 second, thank you for your patience. We're having some technical difficulties here. Our Zoom. We will be with you in just a minute, okay?
Okay.
Thank you.
And what is your name?
Shamika Davis.
Davis, okay. And you live there on the property as well?
Yes.
Okay. And who is Jessica Hawley?
I don't know who that is.
Okay. No, I'm sorry. I'm so sorry. Wrong case. You are with Raymond White?
Yes.
Okay. All right. Perfect. Okay, 1 second.
Okay.
His Zoom isn't working, so he's on a speakerphone, which is right next to my computer, so hopefully you'll be able to
Okay.
hear, okay?
All right.
And if not, I'll just repeat kind of whatever he says.
Okay.
And we've been having some audio issues. Hopefully it's not that way anymore, but we'll cross our fingers.
Hey, all of this stuff is new.
Oh, same here. Thank you.
Okay, we're gonna call in case number LT 2021-1742. This is in regards to James Prince versus Raymond White and all other occupants. This is an eviction hearing, and the property is located at 1518 Red Fox, Wichita Falls, Texas, 76306. At today's hearing, I have Mr. Prince on speakerphone. Is that correct, sir?
Yes, sir.
Okay. And then I have a Miss Shamika Davis, who's in the courtroom at this moment. And you can hear me okay, Ms. Davis?
Yes.
All right, thank you, ma'am. At this time, I'm going to get everybody sworn in. So if you could please raise your right hand. You swear to tell the whole truth and nothing but the truth, so help you God.
Yes.
All right. Mr. Prince, you being the person that filed the petition on this case, you may proceed first.
Okay, well, Mr. White was tasered on the 1st of November, which he never made the pass it, call it, pay later, which was not an aid. And I was the dates that we passed. I think the 26th was the first day he would take care of everything, which he did. His dad offered the piece of paper that he could let his head, which never happened. I sent him a loaded 16 telling him that I was terminating his lease. He said he would not move until the police get out. So that's where we are now.
Okay, so what you had stated was Mr. White missed his payment in November of 2020. Sorry about that, Ms. Davis. That's the technical difficulty I was talking about. We're having some major speaker audio issues there in the courtroom. Okay, so November started his non-payment, and then you gave him a notice to vacate in December. You did provide a document to the court that said December the 7th. Okay. Ms. Davis, we're going to try to get somebody in there to fix that.
Okay.
Is it really loud there in the courtroom when it does that?
No, not really.
Not really?
Hello, how are you? I'm glad. How are you, ma'am?
There's major audio feedback that's almost like it's screaming at us.
Do you still hear it, Judge?
Yeah, no, I can't hear it now. It's just whenever I get to talking a lot, it's when it doesn't like me and all of a sudden it starts screaming back.
Okay, I hear it now. But it's not coming from our end. We don't hear it in the courtroom. I can only hear it from your office, so it's you, sir.
All right, awesome.
Do you want me to come in there and fiddle?
Nah, well, this is the last case, so it'll be all right. But
Okay.
it only happens whenever we're using the courtroom.
That's so weird.
It is weird.
No, I'm sorry, sir. We don't have any in here.
All righty, that'll work. Thank you, ma'am.
No problem.
Okay, we'll see if that works. I don't know if that'll work or not. We'll see. Okay, so you did give notice on December the 7th. And then in January, no rent was paid. They were still there. February, no rent was paid. They were still there. And then in February, you stated you gave another notice.
left him and he moved the house. But he called me back doing hours that we were closed on the afternoon. He still wasn't moving until the police came and told him that he had moved out.
Okay, on that notice on February the 13th, was that just via text message or a message that was left on his phone?
I called and left a message on his phone.
Okay.
He didn't answer his phone. He never had answered his regular phone. But he will return the call
Right.
after business hours.
Okay. Okay. And was any notice given after February the 13th? Okay. And when is the his lease? Was he on a month-to-month lease or was he on a 6-month lease and then it turned into month-to-month?
No, he was on a 1-year lease. Once he violates his leases, because it's no longer good once he violates it, any part of it was just non-payment, of course.
And when did that lease expire?
It would expire on anytime he's due on November the 1st. So he never paid it after then.
Okay.
And I told him, if you don't pay, you violation of the lease.
But was he like on a 6-month or a year lease?
1 year.
It was on a 1 year.
Correct.
Okay. And when was, if he was paying every month, when was his lease supposed to run out?
Okay, I'm looking at the original lease agreement started on the 1st of April. So it would have been out in March.
So April 2020 to March 2021. Okay. Right. Okay. Okay, Ms. Davis, did you have anything that you would like to offer the court?
I don't. Only thing I would say is, as far as November and December, I know it was paid, and I didn't even really look for the receipts for November and December, but I do know January and February, and of course this month we haven't been able to pay because of the utility bills. So actually, I guess I don't have anything to add.
Okay. Now, Mr. Prince, I am showing that you have received a declaration from the
Well, we get the stuff like, yeah, all that stuff is in there, yeah.
right, but did you receive a declaration from Mr. White or Miss Davis?
No, sir.
Okay, all right, because you had checked off that you had. That's okay. That's okay. All right. Ms. Davis, do you know what the declaration is?
No, I do not.
Okay. The declaration is a document that the CDC and federal government has come up with to help tenants in eviction cases. They started this back in the summer. And that declaration states that if a landlord is wants to file an eviction case on non-payment of rent type cases, then you can fill out this declaration if all of these things cover, or if all of these bullet points basically relate to you in your situation. If they do, then you can, okay, and you may have a copy of that declaration on your paperwork that you were served with by the constable's office, my clerk is going to come in there and show that to you. I need you to review that document. If the document pertains to you and you want to sign it, you can turn that in or submit that to the court.
Yeah, those are the qualifications, and then if y'all meet them, then you just sign and date it, both of y'all. And we can give you an extra copy for him.
Okay.
Can you hear okay?
Yes.
Okay.
I'll give you a couple minutes to review that document, okay, Ms. Davis?
Okay.
Sorry about that, Mr. Prince. It comes with two books to the speaker and to the phone and accidentally hung up on it. Sorry about that. All right, hold on 1 second.
Okay, so
Yes, ma'am, Ms. Davis.
if one doesn't apply, I don't need to sign.
Well, basically what that declaration is, and kind of what I was explaining earlier, is if you submit that declaration to the court, because those bullet points are true, and if you sign that, that is a sworn statement. So I have to take it on face value that what you've stated is correct. Then I have to, by law, according to the CDC, that if you're in an eviction case and they're asking for non-payment of rent, then I have to abate or put the hearing on hold until the CDC or the federal government tells the court that, okay, now it's time to hear those hearings. At this moment, the CDC and the federal government have said that March 31st is the deadline that we have to abate all these hearings. Now, the CDC and the federal government started this program in the summer of last year. The first thing they said was it would be at September the 31st. And then they came back and said, well, we're going to extend it till November the 31st. And then they came and they said, well, we're going to extend it till January. Now we're into March 31st that the CDC has decided that we have to abate these hearings, so that whenever the abatement time period is over, then we will rehear these hearings. And that could be January, February, March. That could be sometime in April. Of course, we already have a lot of those cases on the docket that are waiting, but yours would just be, I mean, if this case is abated, then it would just be put on the docket for whenever it comes around sometime in April. So that's the purpose of that form that's in front of you, that declaration, is if you've met those bullet points, and if those pertain to your case, then you could sign that and submit that to the court, and then the court would take that under consideration in regards to this case.
Okay.
I can't answer any questions in regards to the form because
Oh, okay.
that would be legal advice. I can give you legal information, which is what I've been talking about so far. It's just legal information, and it's required by the federal government that I talk to defendants about the declaration form. I have to advise you of this. But I can't answer any of those questions because the plaintiff has the right to contest that document. If they want to contest that document, they have to send us something in writing as well. And then we would schedule a separate hearing for a separate time contesting that document. But once again, that would be at another day and at another time. We would not hear that case today, okay?
Okay. And this, because I wouldn't be signing this just for myself, do I have to wait in order to give him a copy? Or I can make that decision today?
He has the right to fill out the declaration as well, as do you being an other occupant. But with his name on the lease, yes, ma'am, he has the right to fill one out as well and submit that to the court. And going good for a little bit. A defendant in eviction cases, they have until the writ of possession to file the declaration. So basically what that is if I rule in favor of Mr. Prince, and then you have 5 days to appeal the decision of the court or to move out. On the 6th day, if you have not appealed, nor have you moved out of the home, Mr. Prince can come to the court and request what's called the writ of possession. The writ of possession is a 24-hour notice to vacate that the constable will come and post at the residence. Then the constable will meet the plaintiff at the residence, and the plaintiff is able to go into the property, remove anything of value, and place it by the curb. So a defendant has until that writ of possession to file the declaration.
Okay. Okay.
So that would be if you wanted to file it today, if you wanted to file it tomorrow, you can do that, or up until that writ of possession is filed, you have until that time period, according to the CDC.
All right.
Okay.
Thank you.
All right. Did you want to, okay, so you're not wanting to file that as of right now then, is that correct?
No, not as of right now, no.
Okay. Okay, so at this point, the court will rule in favor of the plaintiff, granting possession of the property located at 1518 Red Fox, Wichita Falls, Texas 76306, to the plaintiff, Mr. Prince. And Mr. Prince, it looks like you have written down it's $700 a month in rent.
Correct.
Okay, so that will be the appeal amount. And it looks like you wrote down a rent amount, but you crossed it out. Is that correct?
Oh, did I cross the rent out?
Yes, sir. It looks like it has your initials by it as well. Okay. Okay. So you want to ask the court for, it looks like you're asking for December, January, February, and March. So that's 4 months, a total of $2,800. Is that correct?
Well, I guess I guess it's
Okay, yeah, because you've got December 1st through March 1st. Okay, so we will rule in favor of the $2,800 in regards to the interest, in regards to the court costs, we'll grant that as well. And $2,800 with that $700 appeal amount. So what that appeal amount, Ms. Davis, is if you're wanting to appeal the case, you have 5 days to appeal the order. Okay, I'm sorry.
Okay,
You have 5 days to appeal the judgment. So
okay,
what you're asking is, I made a judgment in the case. You have 5 days to appeal it, which means you want to take it to a higher court because you think I made a mistake in ruling in favor of the plaintiff. So that 5th day actually falls on a Saturday. Well, the court's not open on Saturday. You have until that following Monday, which is March the 29th.
okay,
File your appeal, or to move out, or to file that declaration.
gotcha.
On Tuesday, the 30th, if you have not if you have not done any of those, Mr. Prince can come in and request that writ of possession, which is that 205, which costs $200, Mr. Prince, okay? Okay,
Right.
all right. Do you have any questions, Ms. Davis?
I do not.
Okay, if you do have our phone number. It is attached to that paperwork that you were served with. You can call us at any time, okay?
Okay, thank
All right.
you.
Thank you, Ms. Davis. Thank you, Mr. Prince. Mr. Prince, we will get you this judgment. Ms. Davis, if you wait, we'll give you a copy of the judgment before you leave, okay?
Okay,
All right, and Mr. Prince, we'll get this emailed to you, or we can mail it to you or fax it to you. Which one would you prefer? Okay, put it in the mail today. Thank you, sir. All right, Ms. Davis.
do I just go around to get the copy?
No, yes, ma'am, you sure can. Yeah, just go around to the front window. We'll get it for you.
Okay,
All
thank
right.
you.
Thank you, ma'am. Appreciate your patience.
No problem. Have a good day.
You too. Bye-bye.